Hello po. Our topic for today is about the 1987 Philippine Constitution Article 3 Bill of Rights. So the Bill of Rights refers to the declaration and enumeration of the fundamental civil and political rights of a person with the primary purpose of safeguarding the person from violations by the government as well as by individuals and group of individuals. So it includes the protection of the following rights. Number one is the civil right. Number two is the political right. Number three is the socio-economic rights. And number four is the right of the accused. So the Bill of Rights is directly connected to the natural right, which was discussed before. So Section 1 is the no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. So the protection here refers to all persons, whether citizen or alien, natural or juridical. So the life here speaks about not only the physical safety, but also the importance of quality life. Thus, right to life means right to be alive, right to one's limb against physical harm, and equally important, right to a good quality of life. Life means something more than mere animal existence. So the life here focused also to the quality of life that we had. Pamumuhay natin, di ba? Hindi lang yung humihinga tayo, but no person shall be deprived of life, meaning the quality, a good quality of liberty includes negative and positive freedom. Negative freedom means freedom from absence of physical constraints, while positive freedom means freedom to exercise one's faculty. So, the liberty here focuses on yung kalayaan natin bilang isang mamamayan na hindi tayo captured. And the liberty also focuses here about our freedom in expressing our thoughts, opinion, and in the property naman, so everyone has the right to own a property. So due process, ano nga ba ang due process of law? So there are two aspects of due process. The first one is the procedural and the second one is the substantive. Basically, the procedural aspect involves the method or manner by which the law is enforced, while the substantive aspect involves the law itself, which must be fair, reasonable, and just. Section 2 is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be. So generally, the right against unreasonable searches and seizures requires that before a person is arrested or a personal property seized, it must be supported by a valid warrant of arrest or a search warrant. The exceptions are in cases of valid warrantless arrest and searches. A warrant of arrest is a written order of the court issued in the name of the Philippines. authorizing a peace officer to arrest a person and put him under the custody of the court. While a search warrant is a written order of the court authorizing or directing a peace officer to search a specific location, house, or other premises for a personal property allegedly used in a crime or may be utilized as a tool to prove a crime. So again, Section 1 is all about the right to due process and equal protection, while the Section 2 is the right against unreasonable searches and seizures. Section 3. The privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise, as prescribed by law. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. So Section 3 is the right to privacy. The right to privacy is scattered throughout the Bill of Rights. The right against unreasonable searches and seizures in Section 2 is an expression of this right, inasmuch as it is based on the sacred right to be secured in the privacy of one's person, house, paper, and effects. Due process of law in Section 1 also provides the same privacy security by protecting an individual's life, liberty, and property against undue interference by the government. Section 6 speaks of the right to establish and change one's home, which likewise deals with the privacy and comfort of one's home. The right to form unions or associations under Section 8 and the right against self-incrimination under Section 17 are also privacy rights, which need protection against undue intrusion by the government. Nonetheless, the word privacy is extremely provided in Section 3, Number 1, Article 3, which states that, as I have said a while ago. So here, invasion of communication and correspondence is one kind of search. However, the subject of search is not a tangible object, but an intangible object, such as telephone calls, text messages, letters, and the like. These forms of communication and correspondence may be intruded into by means of wiretapping or other means of electronic eavesdropping. What the Constitution prohibits is government intrusion by means of wiretapping or electronic eavesdropping into the privacy of communication without a lawful court order or when public safety and order does not demand. As a rule, the government cannot intrude into the privacy of communication and correspondence, except when the court allows the intrusion and when public safety and order is demanded. So there are acts associated to Section 3. The first one is the Anti-Wiretapping Act. Next one is the Writ of Habeas Data, and the other one is the Exclusionary Rule. Here, we have the right to protect our form of communications. Yeah, that's why other acts are supporting this Section 3. Section 4. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress or grievance. So Section 4 is the freedom of expression, right? Freedom of expression has four aspects: freedom of speech, freedom of expression, freedom of the press, and freedom of assembly. Nonetheless, the scope of the protection extends to right to form associations or societies, not contrary to law, right to access to information on matter of public concern, and freedom of religion. These are all crucial to the advancement of belief and ideas and establishment of an uninhibited, robust, and wide open debate in the free market of idea. So Section 4 and Section 5 is the freedom to choose your religion, your freedom of speech, expression, or press. Right? So the Section 4 and 5 is connected. In Section 5, no law shall be made respecting an establishment of religion, or prohibiting the free exercise thereof. The free exercise and enjoyment of religion, religious profession, and worship, without discrimination or preference, shall forever be allowed. No religious test shall be required for the exercise of civil or political right. So, freedom of religion has two aspects: the freedom to believe and the freedom to act on one's belief. The first aspect is in the realm of the mind, and as such it is obsolete, since the state cannot control the mind of the citizen. Thus every person has the absolute right to believe or not to believe in anything whatsoever, without any possible external restriction by the government. The aspect refers to the externalization of belief as it is now brought out from the bosom of internal belief, since it may affect peace, moral, public policy, and order. The government may interfere or regulate such aspect or right. So the second aspect is, so in section 5, you have the right to choose what religion you want to join, what you want to exercise, and so forth. Okay? So, walang pakialam. The, the government doesn't have, or you have the freedom to choose what religion you want to join. Section 6 is the liberty of abode and of changing the same within the limits prescribed by law, shall not be impaired except upon lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, or public health, as may be provided by the law. Here, we are focusing on freedom of movement. Freedom of movement has two aspects again: freedom to choose and change one's domicile, and freedom to travel within and outside the country. So, may freedom ka kung saan mo gustong tumira, manirahan, at may freedom ka din kung saan mo gustong mag-travel. Unless, there are some restrictions also. Unless there is a concern on the national security, public safety, or public health. Just like what's happening right now, right? So the traveling is limited right now because of our public safety or public health concern, because we want to avoid the transmission of the virus, right? But still, we have this existing freedom of movement. Number 7 is the right of the people to information on matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development shall be afforded to citizen, subject to such limitations as may be provided by law. So the people has the right to know the date, the transactions of the government, either the local government, the national government, and whatsoever, right? That's why there are some bulletin boards designated in front of the local government office sometimes, and they are putting their records there for transparency purposes. And it falls under Section 7 of Bill of Rights. There are also times that as they say, the SALN, they are releasing the SALN of these politicians para malaman natin what are their monetary improvements. So Section 8 is the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purpose that contrary to law shall be abridged. So we have the freedom to form, to join any association with the purpose of improving ourselves and not to go against the existing law. Yung makakatulong sa atin, right? Number 9, Section 9, private property shall not be taken for public use without just compensation. So, if kung or kung hihiramin ng gobyerno ang iyong property, so they can't just say yes, we're going to borrow it and return it with a thank you. No, the government is going to pay you for some compensation. Section 10. No law impairing the obligation of contract shall be passed. So, because contracts are very important document, so wala daw batas na parang to impair the contract. Section 11, free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. So here, um, everyone has the right to have an access to the court and legal assistance. Hindi dahil mahirap ka, ay hindi ka na pwedeng ipagtanggol sa korte. So that is the content of it. That's why there are existing, diba? There are existing offices that will help us when in terms of those times, like the public attorney's office and many more, right? Kasi mahirap ka na nga tapos hindi mo pa maipagtanggol yung sarili mo. Diba? Ganun. Next one is Section 12. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of court counsel. Sorry. Number 2, no torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. Number 3, any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. 4. The law shall provide for penal and civil sanction for violations of this section, as well as compensation to the rehabilitation of victims of torture or similar practices and their families. So section 12, 1 to 4 is actually referred to as Miranda right because it is an adaptation of the rights provided in the American case Miranda versus Arizona. So here in section 12, 'di ba, when someone is being arrested, so the police officer will inform the arrested person about his rights, 'di ba? They keep on saying karapatan mong manahimik, karapatan mong kumuha ng abogadong magtatanggol sa iyo, karapatan mo anumang sabihin mo ay magagamit laban sa iyo. Those are the things that um, a police officer will inform an arrested individual, right? And here in section 12 also, wala daw or it is not right to or no torture, force, violence, threats, intimidations kapag na ano ka lang or any other ano, 'di ba? You are detained. You are just detained. Then here in section 12 number 3, ayun nga, anything that you say will be used against you. Number 4 is yan, if you are a victim or if a if a person that is um, arrested undergo gone torture, force, violence, and many more, they are given compensation. Ayoko namang magpa-torture para lang magkapera. No. Section 13. All persons except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong shall before conviction be bailable by sufficient sureties or be released on recognizance as may be provided by law. The right to bail shall not be impaired, even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. So section 13 refers to right to bail. Yes. So ano ba ang bail? Bail refers to the security given for the temporary release of a person in custody of the law, furnished by him or a bondsman, conditioned upon his appearance before any court as may be required. For instance, a person arrested and detained for the offense of homicide may post a bond for his temporary release on the condition that he will appear in the court during the trial or when the court so required. So, provisional release through bail is corollary to the right to be presumed innocent and means of immediate obtaining liberty. During the duration of release, the accused is given the chance to prepare his defense and thus level the playing field for the parties. Worth emphasizing is the reason which those charged with offenses punishable by reclusion perpetua and against whom evidence of guilt is strong are not allowed to bail. So, kapag napaka grave ng offense na yung case mo, you don't have the right to bail. But then, if your offense is quite light, you have the right to bail. But then, a lot of Filipinos, especially those, the poor ones, can't avail to bail themselves because, right, ang mahal, di ba? Kaya they just go to the to the prison while waiting for their trials, right? Section 14, number 1. No offense shall be held to answer for a criminal offense without due process of law. Number 2, in all criminal prosecutions, the accused shall be presumed innocent until the contrary is proven, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusations against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable. So section 4, number 1 is the provision refers to due process in criminal cases. As to its procedural aspect, criminal due process requires that the accused is brought into a court of competent jurisdiction. He is notified of the case. He is given the opportunity to be heard, and there is a valid judgment deliberated and rendered by the court. So, ang tao ay ang taong accused ay hindi pwedeng sabihin criminal unless with the proper due process. Diba? Sabi nga dito, um, the accused shall be presumed innocent. Ayan. Then, these are under section 14 number 2, these are the rights of an accused individual. Section 15. The privilege of the writ of habeas corpus shall be suspended except in cases of invasion or rebellion when the public safety requires it. So what is writ of habeas corpus? Writ of habeas corpus is a written order issued by the court directed to a person detaining another commanding him to produce the body of the prisoner at a designated time and place, with the day and cause of his capture and detention to do, to submit to, and to receive whatever court or judge awarding the writ shall consider in his behalf. When a person is illegally confined or detained, or when his liberty is illegally restrained, he has the constitutional right to file a petition of habeas corpus. Should the court find out that the person is illegally confined or detained, he shall be immediately released from detention. Section 16. All persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. So all citizens, aliens, natural or not natural born citizen of the Philippines has the right to a speedy disposition of their cases. Mabilisang pagproseso ng mga kaso. Section 17. No person shall be compelled to be a witness against himself. So Section 17 is also known as the right against self-incrimination. The right allows a person not to answer an incriminating question. An incriminating question is one that is answered renders a person liable for an offense. However, it is only when the incrimination question is put to a witness stand that the right may be invoked. So, tinatanong sa'yo, pinatay mo ba siya? Tapos, kapag sinabi mo, yeah, like that. Yeah, just like that. Section 18 is no person shall be detained solely by reason of his political beliefs and aspirations. So, wala daw dapat ang tao na naikukulong dahil naniniwala siya sa kanyang mga political beliefs and aspirations, di ba? Unless those beliefs are incurring public safety, public health, and national security. Diba? Section 20, or Section 19, I should say. Excessive fines shall not be imposed, nor cruel, degrading, or inhumane punishment inflicted. Neither shall that penalty be imposed unless for compelling reasons involving heinous crimes. The court hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. So here in the Philippines, we don't have, okay, before we have that penalty, but then they removed it, and all those people who were punished to have a death penalty, they reduced their sentences into reclusion perpetua or lifetime imprisonment. Yan. And number two, under Section 19, is the employment of physical, psychological, or degrading punishment against any prisoner or detainee, or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with the law. So here, kahit na nagkasala sila, they are in prison, it says that they still have the right for a humane facility for them to live. But then the Philippine government's prison facility or the facilities for prisoners here in the Philippines is not, I don't, hindi ata siya humane na kasi para na silang sardinas na nagsisiksikan, di ba? I saw some documentary about the kulungan ng mga Pilipino. It's really awful. Yeah. But then the kulungan ng mga mayayaman is very good. You know? Section 20. No person shall be imprisoned, for debt or non-payment of a poll tax. So, hindi ka dapat makulong or walang nakukulong dahil sa utang. Just like that. No person shall be imprisoned for debt. So, utang lang tayo ng utang. Joke. Section 21. No person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law or an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Double jeopardy means that the person is twice put at the risk of conviction for the same act or offense. The right against double jeopardy, therefore, means that a person can only be indicted or charged once by a competent court for an offense. When a person, for instance, has been charged of homicide and the court acquitted him of the case, he can no longer be prosecuted for the same offense or act. He can now invoke his right against double jeopardy. So, kapag nasentensyahan ka and hindi ka na pwedeng masentensyahan ulit. Ganun. Section 22. No ex post facto law or bill of attainder shall be enacted. An ex post facto law is one which makes criminal an act done before the passage of the law which was innocent when done and punish must such an act aggravated the crime or make it greater than it was when committed, change the punishment and inflicts a greater punishment than the law and annexed to the crime when committed, alters the legal rule of evidence and authorized conviction upon less or different testimony than the law required at the time of the commission of the offense, assumes assuming to regulate civil right and remedies only, in the effect impose penalty or deprivation of the right for something which, when done, was lawful, and deprives a person accused of a crime of some lawful protection to which he has been entitled, such as the protection of the former conviction or acquittal or a proclamation of amnesty. So ano ba ang Bill of Attainder? It is a legislative act which inflicts punishment without trial. Its essence is the substitution of a legislative for a judicial determination of guilt. So for example, this no ex post facto law or under this section 22, in one case, the court held that the Anti-Subversion Law, RA 1700, is not a bill attainder. The law declares that the Communist Party of the Philippines, or the CPP, is a clear and present danger to Philippine security and thus prohibits membership in such organization. It is not a bill of attainder because it does not define a crime, but only lays a basis for the legislative determination that members in CPP and any other organization having the same purpose is a crime. It does not automatically secure judgment by mere membership. In operation, the law does not render unnecessary judicial proceedings. The guilt of the individual members of the subversive group must still be judicially approved. So, ang naintindihan ko po dito sa Section 22 ay here, specifically the ex post facto law, may ginawa kang kasalanan, then pa pa-approve pa lang yung batas na nagko-cover sa um, kasalanan mo upon the doing or while you're doing the act, you are innocent. Then kapag na ipasa na yung batas na yon or a certain bill or act or ordinance, I guess, hindi ka pwedeng i-charge nun because when you did that act, you were innocent and you are not violating any law. Yan. For example, before, or let's impose that no face mask is an ordinance, then you will be punished for first offense 2,000 pesos. Way back January 2017. So, nung 2017, hindi ka pa nagmamask. Then, the ordinance um, was made today, right? Your action before is not a criminal or is not an offense kasi ginawa mo siya noon bago nagkaroon ng ordinance na ganito, di ba? So, that's it. So, wala dapat daw ganun na ma-end up or walang ganun. So, let's move on to the next topic, I guess. This is from a website, Project.org, Human Rights in the Philippines. So, these are the 10 important facts about human rights in the Philippines. So, this was written because of their observation on what's happening right now here in the Philippines. Let's see. Human rights are the basic rights inherent to all human beings from birth until death. These rights include the right to life and liberty, personal security, freedom from torture, freedom from discrimination, and freedom from arbitrary arrest, among others. Since the election of President Rodrigo Duterte in 2016, it has been widely alleged that these and many other basic human rights have been violated in the Philippines. According to Human Rights Watch, Duterte and his war of drugs has plunged the Philippines into its worst human rights crisis since the dictatorship years of the 1970s and the 1980s. So these are their observations. These are the 10 facts about human rights here in the Philippines. So as of January 2018, Human Rights Watch claimed that 12,000 drug suspects has been killed since the war on drugs, since it started last July 1, 2016. So dami no. So these are the killing related to drugs as of July or as of January 2018. From July 1, 2016 to September 26, 2017, 3,906 suspected drugs users and dealers were killed by police. These numbers from the Philippines Drug Enforcement Agency do not include death by unidentified gunmen. These so-called extrajudicial killings have been responsible for thousands more deaths. An average of 4 Filipinos a day are killed by drive-by motorcycle attacks, according to data from the Philippines National Police. Between July 1, 2016 and September 26, 2017, there are 118,000 drug personalities that are arrested and 1,308,000 others surrendered to authorities. Police have killed 56 children since the start of the war on drugs, according to Human Rights Watch. Since 1986, 177 Filipino reporters have been killed. According to the Reporters Without Borders, the Philippines was the deadliest country in Asia for journalists in 2017. The President Duterte has continually vilified journalists who have been critical of his administration. So, ay, so 'di ba? If you talk bad things about the government and the president, you might not di ka nasisikatan ng araw, sabi nila. Oh my God. The Department of Labor and Employment reported that as of 2017, 18,000 women and children worked in dangerous small-scale gold mining operations in the Philippines. The Department of Social Welfare and Development stated that 85,000 child workers or child laborers work in the agricultural sector in the Philippines. More than 8,000 Filipinos were arrested from June 13 to June 26, 2018 for violating new anti-loitering law. Anti-loitering law is the law that have been labeled as discriminatory, essentially targeting and jailing poor Filipino for being in public. Because anti-loitering law is kapag pagala-gala ka sa gabi, what if you're homeless, right? What if you don't have any hope to go with, right? Yan. That's why it is a discriminatory law targeting the poor Filipino people. As of September 2017, 94% of Filipinos behind bars were still waiting for their first day in court. Kasi nga, di ba, they don't have enough money to bail themselves. That's why they were, they just went there. Di ba? They don't have money for bailing eh. Di ba? Step-by-step improvement according to this site. Despite the precarious condition of human rights in the Philippines, the Duterte administration enjoys the highest public approval rating on record for a Filipino government dating back to the 1980s. Mataas daw ang approval rating ng Duterte administration according to a certain survey. On the other hand, international criticism of the administration's war on drugs and human rights record continues to pour in. So, ang daming nagkakriticize sa form of government or the war on drugs platform ni Duterte. It's encouraging that the international community and numerous Filipinos have refused to stay quiet over the current human rights condition. As a result, the topic of human rights in the Philippines has become a prominent global issue, which in itself is a step of the right direction towards positive change and improvement. So the the things that's happening right now is a global talk because of all those things that's happening right now, our human rights were um, neglected. Yung mga nasa Bill of Rights, hindi yun nasusunod, di ba? A lot of things are not being followed na. Para saan pang ano, di ba? That's it. So, that's our lesson for today. So, I hope you understand the Bill of Rights. And because of that, this is your final output for ethics in connection to our discussion. So, there are 22 sections under Bill of Rights, right? Under Article 3 Bill of Rights. So, magbigay ng isang halimbawa sa bawat section. Ang mga halimbawa ay pwede mong nakita, narinig, or personal na na-experience. Pwede din kapag nabasa mo sa internet, sa Facebook, or many other platforms, di ba? O pwedeng naalala mo lang na nakita mo sa TV noon. Pwede din. Pwedeng gumamit ng Filipino or English sa output na ito. Yes. But I highly encourage you to use kung ano yung mas edge nyo. Kung sa English kayo mas edge, edi mag-English po kayo. Kung mas prefer nyo pong gamitin ng Filipino, it is just okay to me. Pwede nyong isulat sa notebook at picturean or sa isang pirasong papel ang mga sagot ninyo. And pwede din po kayo nung i-type kung you have laptop or any other electronic device. Pwede nyo siyang i-type, then i-react nyo po. Then the thing that you're going to do is write first the section. For example, section 1. Ano ang section 1? Then under that is your example or halimbawa na experience or scenario na nakita nyo po. So, the content of your final output is 22 sections times 10 points each. It will be 220 points. So, ayan. Kung wala po kayong mahanap na, madami po sa internet actually. You just need to search and understand. Ayan. So, yan po ang iyong final output for ethics. I hope you understand our lesson for tonight. And for questions, I'm going to accommodate it. Yes. Thank you po.